Thanks everyone for staying with us for our last panel of the day. It will not disappoint. I am Leta Jones. I'm a graduate of CU Boulder's Atlas program in the engineering school here. And when I was here, I also worked at Silicon Flatiron. So I'm very happy to be back, and I'm excited to have this crew with me to talk about technology transparency trade-offs, which of course, when you do the last panel, your thing has already come up a bunch. And so we've talked a little bit about this before, but we're gonna focus on transparency trade-offs. But I would also like us, I think it would be beneficial to me, and I bet a lot of other people, to also think about framing. Like, how should we walk out of this room at the end of today and think about transparency, tech and transparency? We also have one panelist who is zooming in. Let me do introductions, and I'll start with you, Hannah. Hannah Bloch-Wehba is an associate professor at Texas A&M School of Law. I think this is working magically. It's very impressive. On the end, we have Eric Goldman, professor and associate dean of research at Santa Clara University School of Law. Next to him is Emily McReynolds, who works on AI policy and research at Meta. And then next to me is Chris Morten, associate clinical professor of law at Columbia School of Law, and Patty Limerick, who is a professor of history here at the University of Colorado. So let's get into it. Our first question was sort of teed up in the last panel, but if you weren't paying attention to the entire thing, a lot of things happened in the last panel. So Eric, could you speak to one of the questions that came up before, which is how we should think about free speech law as it prohibits transparency, which to me, and probably for a lot of people, seems counterintuitive. What limits does the First Amendment place on transparency, specifically with regard to content moderation disclosures?
Thank you, and I'm so delighted to be here. Thank you to Silicon Flatirons for organizing this event and putting together, and to my co-panelists and to our moderator for doing such a great job. Let me just start, just to make it clear, we're going to talk about trade-offs on this panel. I'm guessing, and certainly I am, pro-transparency. Who isn't, right? We all want more information. That's just a thing that we all value is we want to know more. We feel we have greater agency and control when we know more. And I'm a researcher. Of course I want more information. I can do more things if I know more about what's going on. But that's voluntary. When we get voluntary disclosures, then that's between the company and the public, and that's fine. It's the mandatory transparency that starts to raise questions, and Amanda already covered the ground more beautifully than I could. So I'm going to just carve off a slice of the issue and really focus on a category of compelled transparency that I call editorial transparency. This is trying to get into the editorial decisions and operations of companies. How are they structured? What are they doing? What decisions have they made? And what policies are they following? In my papers, I lay out a taxonomy of different types of ways that these regulations can be structured. One is that you can structure disclosures about a company's editorial policies. So this is saying, tell us in your terms of service what things are okay and what aren't. We can have another set of disclosures that are basically explanations, which have come up several times today. Tell us why you made the decision that you did. Now, could come up in the privacy context where you say, explain to us how your algorithms work. But in this context, I'm thinking about explain to us why you chose to publish something or why you chose not to, why you chose to put it above something else. Tell us why you gave this many words to the story, and why you chose to feature it or not. A third category is statistics. Tell us what percentage of things you did. We talked about it earlier about this prevalence rate. What percentage of the items do you actually catch, or how many times have you removed an item for a particular reason? And there's a fourth issue, and this is the one that I find a little frustrating when I talk about transparency, because often I find people don't think about it or get to it. It's what I call the source data disclosure. In order to actually evaluate the accuracy of any of the disclosures that we just discussed, we need more information from the company to see what they saw. So for example, if they chose to unpublish or never publish things, in order to then calculate the statistics, we need to see that unpublished or depublished material. Or if they're applying their editorial policies properly, we need to see what they actually what they did screen out in addition to what they didn't. And so, and I can't remember who said earlier today, actually each of those raises its own constitutional questions. We actually have to analyze them differently, just like we would any other kinds of transparency. One size doesn't fit all. We have to say, what is this law requiring? What does it do? I'm a skeptic of all of them from a legal standpoint because of really two things that I think Daphne really highlighted earlier today. First, the fact that in order to do the enforcement, the government's going to be rooting around in this source data saying, tell me what you saw and let me come and second guess those decisions. Now, we might not care if we're talking about sugar content in a can of corn, but we care a lot when the government's coming and saying, why did you publish this? What was your rationale? How did that fit your rules? Did you properly disclose in your statistics? And I'm going to second guess all of that. And so that enforcement issue, I think, becomes very problematic because it basically puts the government in the role of the editor's shoes, saying, I'm going to question what you did and why you did it. It also, it should be acknowledged, as again, Daphne pointed out, that many of those enforcements will not be done because they're trying to get to the truth. It's going to be done for partisan reasons, because publication is a power center and governments want to control that power center. So the reason why they're bringing the enforcement is because they think there was a falsity. They want to try to exercise their power in order to advance a usually partisan agenda. So this integral interaction between the editorial function and the government coming and second guessing it creates, I think, a whole range of constitutional friction. And if you ever are a fan of transparency being compelled, ask the question, how's it going to be enforced? Who's going to enforce it? What are their motivations? And what are the consequences when that is weaponized for a purpose that you don't support? The other concern is knowing that there's this hammer of enforcement hanging over the heads of the publishers, they change their decisions in advance. They look for the lowest friction decisions that will avoid the risk of a future enforcement for partisan agendas. So that means basically they're pre-guessing what the enforcers want and then providing that to them. Not what's in the best interest of their audience, but in the best interest of keeping the enforcement tangles low. And I'm sorry, I can't recall who was sitting here earlier talking about the cost of dealing with those enforcement, the requests, but that actually is in spades when it comes to these publication decisions. The government coming in and saying, we don't like what you're doing. We're going to use the powers of our enforcement tools to change your behavior. So these are the reasons why I have skepticism from a constitutional standpoint about all of the different types of transparency that could be compelled from editorial operations or decisions, because of the fact that in each of those cases, they're changing the publication decisions in a way that distorts the freedom of speech and press.
Thank you, Eric, for putting that landscape in place for us. I feel like all of our participants can build off of different areas. I just want to follow up really quick on the last thing you were talking about in terms of bipartisan weaponization. Is what you were just saying true for all mandatory disclosures, and you're like, let's not do more of those, meaning that all mandatory disclosures are being weaponized for partisan reasons and we don't want to add to that plate, or that there's something special about this particular weaponization of mandatory disclosures that you're not interested in?
Yeah, and I do think that's the question that you should be asking with every type of mandatory disclosure. Again, who's the adversarial threat in this equation, and what are they going to do to advance their agenda? But I really think there's something unique or special about editorial disclosures, about trying to get into the newsroom or the heads of editors and saying, what are you doing and why are you doing it? Getting into their heads is a qualitatively different thing than getting into the heads of a manufacturer of ordinary goods and services, where if they change their decision, it doesn't have speech implications the way that if a publisher changes their decisions, it unavoidably has speech implications.
Great, thank you. Editorial decision making inside people's brains, one version of transparency trade-offs. Hannah, I want to ask you about automated decision making, also known as algorithmic accountability. Can you talk to us about the trade-offs, maybe inherent or just the ones we're looking at with algorithmic accountability, and what limits there should be, given that often the algorithmic decisions are made using highly personal data and producing highly personal inferences?
Yeah, so first of all, I want to say thank you for having me. I'm so sad that I'm not there in person, but I guess my, disembodied head on a screen is almost as good. And thank you, Meg, for moderating. So I want to build a little bit in the second half of what I'm talking about on what Eric was just saying. But to start, I want to sort of situate the debate about algorithmic transparency within a broader sort of debate about accountability. So I'm really thinking about the use of algorithmic decision-making in public sector settings, right? So what happens when the government uses some kind of algorithmic tool to make decisions that have like dramatic implications for people's rights and their livelihoods? And so in this setting, we're really talking about accountability for government actors as well as accountability for technology, right? We're thinking about technology as it sort of interfaces with government programs. And so I find it sort of helpful and necessary to articulate a little bit what the potential overlap and maybe differences between algorithmic transparency and government transparency might be. Because to some extent, when we're talking about transparency in this setting, we're talking about a necessary precondition for accountability, both of the technology or of the people who made the technology and of the government itself. And that's sort of the basic presumption of government transparency law, is that you can't hold to account what you don't know about, and you need transparency as a precondition for accountability. But the usefulness of transparency and of different forms of transparency enhancing intervention depends then on the kind of thing that you're trying to learn. So when we're talking about government transparency, transparency is a crucial component of self-governance and democracy. It's at the core of press freedom and free speech. But when we're talking about algorithmic transparency, it's not always self-evident what kinds of values we're seeking to serve. Right? We have a sort of shorthand understanding in the government transparency context of what those values are. We could just call them democracy values. But in the algorithmic transparency context, it's not always so obvious. You might think that given the sort of increasing democratic salience of technology, there are also democratic values at stake here, right? Particularly in the public sector context. But a lot of the time, there are also concerns that transparency might serve counter-democratic values, for example, by allowing bad actors to game the system or to effectively steal individual data, right? So it's not always obvious that transparency as such is necessarily a good thing. I'll come back to this in a couple of minutes, because I think the answer to whether transparency works depends on how it's designed. So one helpful way to think about algorithmic transparency I draw from the work of Jenna Burrell, who has sort of distinguished between three different kinds of algorithmic opacity, right? There's opacity as secrecy, right? Algorithmic opacity as intentional concealment of some kind of decision-making mechanism. There's opacity as lack of knowledge, which is we might all know that an algorithmic decision is happening, but we might actually lack the ability to understand how it's working in practice. And then there's opacity as sort of incomprehensibility, right? Technological opacity that's caused by the way that an algorithmic decision-making mechanism is designed. And this is, I think, most sort of obvious in the context of AI and machine learning. So when we think about those three different kinds of opacity, it becomes clear that like we can't just sort of slap a uniform transparency mechanism on to solve all three of those problems, that existing sort of transparency as disclosure regimes might effectively combat intentional concealment, but they don't help us get the information that we need to comprehend how an algorithm actually works in practice. And so if we wanted to design an effective algorithmic transparency regime to promote accountability, then we have to get at a sort of richer menu of problems. Okay, so I want to come back then to the second part of your question, which is about what are the limits to transparency? You know, I think as lawyers, we often have a very particular vision of transparency as disclosure to the public, right? And that's in part informed by our legal system, the right to know laws, like the ones we were hearing about on the last panel, or by, for example, rights to notice, right? The right to know that something is happening, whether it's general or whether it's about me specifically. But one thing that we learn from distinguishing between government transparency and algorithmic transparency is that there might be a richer menu of options to enhance transparency than just compelling public disclosure. And so in some of my work, I've tried to distinguish between, you know, transparency of what, to whom, and at what time. So for algorithmic decision-making, we might start by asking, what are we trying to enhance transparency of, right? The fact that a system exists, that it's being used, that a decision is happening, that it's happening to you particularly, and who should know that this is happening, whatever the what is, who should know about it, right? Is it the person who's affected? Is it regulators? Is it courts? Is it the general public? And then there's the question of timing. When should we know, right? Should that happen before a decision is made? Should it happen after? Should it happen repeatedly, continuously? And so I think disaggregating these kinds of questions helps us to think about, right, could we imagine an algorithmic transparency regime that is more sensitive to privacy because it doesn't entail public disclosure of the kind that we've been sort of conditioned to think of as the gold standard, right? So we've been trained to think about disclosure as the paradigm of transparency, but I think there are now, in these sort of novel and emerging algorithmic transparency efforts, a much more nuanced set of tools. So I'm thinking about impact assessments, which tell us how automated decisions have certain kinds of effects on society. Audits, which tell us more about how the technology is actually working, and researcher access to certain kinds of automated decisions without public disclosure. So I think it's possible, in short, to imagine transparency enhancing regimes with a much more limited sort of role for public disclosure and a much heightened role for other forms of knowledge to emerge.
Thank you so much for organizing that so neatly. One of the things that you said related got me thinking about the question that I asked Eric, and I'm going to use it as my transition here to Chris, which I'm thinking about whether incomprehensible opacity is particularly vulnerable to weaponization, and the trade-off is a significant loss in legitimacy. And so, Chris, when we think about trade-offs with regard to scientific information, technical or medical knowledge, transparency of those types of information, how should we account for these many actors and the current state of affairs? So given the increasing ease of identification, how should we consider public disclosures of specifically scientific and medical information? And related to Hannah's last remarks, what privacy, related limits should we have in those contexts?
Yeah, thanks so much, Meg, and thanks so much, everyone. It's really a pleasure to be here. And as I think Meg's question kind of previews, I'm a little bit of an interloper in this group. So I'm not a data privacy lawyer. I'm not someone who works on content moderation. I'm really a health lawyer. And in that capacity have worked on the governance of scientific and medical data, including sensitive personal medical information and including information that is trade secret or is alleged to be trade secret information. So I bring a little bit of knowledge of sort of how that knowledge is governed. Yeah, so I'll say I sort of agree with the premise of the panel to a point that there are trade-offs to transparency. But Meg, you asked, I think, a little bit about framing, and I will kind of simultaneously, I think, challenge or problematize the frame because I don't think there's a simple trade-off here. I think it is possible to unlock benefits that are greater than the downsides, or that the trade-offs are not linear. And this goes actually to something that Hannah just said, that when we think about transparency, I think some of us as lawyers, I at least as a lawyer for a long time, thought about transparency as meaning public disclosure. And that comes from the Freedom of Information Act. It comes from a lot of kind of open government laws. It comes from a lot of places in the law, but we tend to think of transparency as an on-off binary choice. But to quote Hannah again, I think we actually have a much richer menu of options, and the history of data sharing in science and medicine shows that. And that means that we can unlock some of the benefits of data sharing without exposing individuals to great harm and without exposing companies that share information to great harm. So that's the kind of main thrust of my remarks. So I'll say kind of in connection with that, I'm optimistic and supportive of legislation and regulation that would mandate more transparency from tech companies today. And I feel, particularly having listened to the panels earlier today, it seems clear to me than ever that the tech industry is too secretive, and we, the public, should develop responses to that. So let me get a little more concrete about kind of the medical and scientific data sharing that I'm referring to, and I will plug shamelessly a paper that I'm working on with Salome Viljoen at Michigan and Gabe Nicholas at the Center for Democracy and Technology. So we actually have something in the works about lessons from medical and scientific data sharing that we think are transposable or applicable to social media platforms and other tech companies. So in science and medicine today, we have, after much contestation and much experimentation, legal and institutional and technical frameworks that permit sharing of intensely sensitive data. So this includes clinical trial data, includes individual patients' medical records, genetic data, commercially valuable data on how companies conduct their R&D, and much more. And we have public and private bodies that steward and share this data with third-party researchers. I should say, actually, most of the focus of what I'm talking about here is researcher access, and I understand that there are many other sort of important facets to transparency, and researcher access is the facet that I know best. So quickly, I'm glad to talk more about this if folks are interested. We have, for example, working data sharing programs that the NIH, National Institutes of Health, administers, Food and Drug Administration. Canada's health regulator goes even farther than FDA does. We have private data sharing initiatives at universities like Harvard and Yale that take sensitive medical data and make it accessible to researchers. And we have now federal law that mandates that drug companies, device companies, other companies with very strong incentives to secrecy that resisted data sharing for decades are now obligated to share data, some with the public at large without condition, without restriction, and some in these more selective and conditional ways that Hannah gestured at. So I'll say again, yeah, I think the choice between secrecy and transparency is not on, off, or binary. We have in medical and scientific data sharing, all sorts of tools, legal tools, technical tools to constrain who gets access, limit who gets access, limit what uses they make of data. And a couple of the important ones, glad to talk more about this. Data use agreements are now ubiquitous. We have technical constraints that prevent users of data, researchers from downloading complete data sets. We have differential privacy in some limited contexts. All of these in various ways shape the uses that are made. I also think it's really interesting, the law and the specific data use agreements that are imposed on researchers often impose positive commitments on the users of data. So they're obliged, for example, to report safety problems to regulators. I think all of this is really interesting, and perhaps some of this could be applicable. By the way, Meg, you mentioned, I think, specifically the risk of re-identification, and I will say that's something, a concern on my mind, I think a really vivid, important concern when you're dealing with individual patients' medical histories. A lot of people whose data is implicated here are some of the most vulnerable already. And the tools that medical researchers and the data sharing stewards have come up with sort of keep the risk of re-identification at the center. So I think I'll stop there. I'll just reiterate kind of the point that I started with there, that I don't think the trade-offs are linear here. I think more access or more transparency, at least in terms of researcher access, does not necessarily mean proportionally more harm or more risk. I say that again with some humility. That's the world I know, and I realize there are a lot of differences when we get to platforms.
Well, Chris, that sounds great. Should we just do that? I mean, I feel like you just pitched us. Tell me one downside to this. Tell me one thing that doesn't work well in this system.
Oh, God. Oh, so there are huge problems. Okay.
Okay.
Disclosure.
Yeah. So I'll echo, I mean, some of the really, really important problems that others have said. So I think medical data sharing today is working much better. Like pharma and biotech companies today have to share certain kinds of data. Do they comply 100%? No, they do not. And I, as a lawyer, I've litigated, I've done advocacy, I've done other work to try, for example, to increase compliance by drug and medical device companies with a federal law that requires them to report the results of clinical trials and report their methodology when they run clinical trials. Compliance with that law today is about 75%. So not perfect, and there are problems of enforcement, et cetera. I step back though and I say 75% compliance is pretty good. There are things that we can do with 75% compliance that we couldn't do with 0% compliance. And the world of data sharing today is far better than it was 20 years ago when we relied on voluntary commitments from these same companies, when they would cherry pick which data to share, et cetera. So, but that is, the problem of lack of compliance, the problem of lack of resources in the public governors of this data, so NIH and FDA, huge problem. Problems of capture and institutional inertia, all problems.
Okay. I thought maybe there was something to this. But thinking about mandatory disclosures of data is a great, I think, question to pose, or a great subject to pose to Emily, who works at Meta. Emily, tech companies are approached for a ton of data all the time, and transparency regimes can expose lots of user data that makes users really, really vulnerable. When companies like Meta see regulatory calls for increased transparency, how do they and how should they think about them?
Thanks, Meg, and thanks for the invitation to be here. I wanted a little bit situate my expertise in what I do in answering this question. So I'm on the AI policy team at Meta, and what that means is sitting in the privacy and data policy team, we think a lot about the implications for data and how that comes up in machine learning and AI. And where we sit, I think, highlights the importance of thinking about what we do with data in terms of transparency. So the AI policy team works across the company on issues like AI transparency. We act as the internal subject matter experts. So looking at provisions, the proliferation that we're seeing of important potential regulation from the EU AI Act to Algorithm Accountability Act here in the US. Usually I have a slide that's a big picture of the world and so many bullet points of all the things we're looking at. We have transparency efforts in Asia, in Latin America, looking at all the different laws that are coming and how we can respond to those. I think it's really important to be responsive to these proposals and how they might be implicated, but I'm coming at it from a research perspective. So I've spent a number of years looking at how we do documentation, how do we do impact assessments, how do we think about those things in an effective manner. So when I work with our research teams or with our internal product teams, I often bring in external expertise. I come to events like this and I learn new things about approaches from healthcare data experts. And thinking about it in terms of building these standards in a cross-disciplinary, cross-industry, cross-regulatory way, I think that's obvious for an international company, but the influence that research plays in that space, it might be less obvious. One of the things we have is an approach through 5 pillars of responsible AI. And so when you're building AI responsibly, after a proliferation also of principles, I think we're over 85 sets of principles on how to do AI ethics and deal with these kinds of issues. And so one of those is transparency. And I'll call back to Hannah here. When we're talking about transparency, when we're talking about explainability, which are sometimes used interchangeably, it's really of what, to whom, and when. So when we look at the different options that regulators are exploring, that companies are considering complying with, what does it look like? Is the trade-off in my opinion shouldn't be between sharing data or not sharing data. But sometimes the data isn't the most helpful thing. What you want to understand isn't maybe 1,000 models that have built a system based on millions of points of data. You might want to understand why the system exists. So over the last year, the Meta launched this year the AI system card. So there's about a 5-year history now looking at how you look at data, how you provide transparency around data, how you provide transparency around machine learning. So everything from a data nutrition label to a model card to data statements when working in natural language processing. I'm citing a lot of academic work. And if I listed all the names, we would be here 10 minutes from now. So just know, huge amount of respect to the researchers that are still working on this today. I think what we've come to is, in explaining what, to whom, and when, really thinking about levels of explainability. And so the company, and particularly the responsible AI teams that I work with, have thought about who needs what explanation when, and how much data might be required for that, how much information about the machine learning model might be required for that. One of the things I'm really proud of is some of the academic publications we've done around this topic. Really exciting titles like Prescriptive and Descriptive Approaches to Machine Learning Transparency. But what that says in sort of a user-facing and a public-facing way is that we're trying to provide the transparency that is being asked for. And there are trade-offs in how to approach it, but to directly answer the question, I think companies should and need to be responsive to regulation that's being considered and be a part of these kinds of conversations.
Great, thank you so much, Emily. I think that is one of 2 narratives around transparency that Margot and I had been talking about as we were speaking with Patty before the conference. So Patty's really an expert on narratives in her own career. And let me tee this up properly. So we were talking about how transparency is kind of in this position where there's like 2 teams. One are like, yeah, transparency is vital. It's obviously important for accountability, versus it's really corrupt and it's just not worth much, and we should be spending our time on other things to try to do governance. As an expert in narratives and counter narratives, and maybe an expert on that topic's not right, but I think you have embraced this as part of your career as an author of really one of the most notable texts on the history of the American West. I would love for you to talk about how you came to maneuver within a narrative that you had challenged and why you did that, and how we might think about moving forward within or around an idea of transparency.
I think I can do that.
All right.
We'll find
Great.
out. So Western American history, oh my goodness, more than 35 years ago was really stuck in a, shall we be celebrating the westward movement of white men? Or should we look at the whole complexity of the population? And it looked like we were going to be locked there for a really long time. And it was so boring. We had argued that just into a corner. That debate just wanted to go away and die or rest, I guess. So but we just kept at it. So we were doing this, shall we be honest and accurate in our version of Western history and debunk it, or shall we hold to some forms of identity that are crucial to some people? I mean, these have some relevance in American society today. But anyway, so that was where I was on the debunking side, and I was fierce and I was persistent. And several years passed with me just debunking away with everything I had, and then suddenly thinking, I'm not getting anywhere. I'm having no impact. And the people who already agreed with me, oh, they are really, really agreeing, but they already did. So this is not satisfying. And maybe it had some minor satisfaction of self-indulgence, but not sufficient. So I just felt that I certainly wasn't gaining ground. And I went to speak in Durango at Fort Lewis College once, and the New York Times, this is quite a few years ago, had a inside the front page ad for a book about the American West, a novel called The Heart of the West, and it was very overstated and clearly a nonsensical book. And I held that ad up to the students, and I held my book, Legacy of Conquest. And I said, okay, students in Durango here, vote. How many points would you give to the influence of my book, Legacy of Conquest? And how many points, scale of 100, would you give to this Heart of the West? And it ended with, oh Lord, something like Montana was not the only frontier for the school marm who was facing the law. It was such a ridiculous thing. So it was very clear how they should vote. No, these very honest students, honest to a fault in Durango, they voted, they gave the colorful Heart of the West book 99 points, and they gave my book 1 for influence and impact. Well, should we weep? No, we won't weep. But we'll say that there's a lesson there that I finally just thought, this can't go on like this. This is getting ridiculous. So that's when I did what Mega's talking about here. I just thought, okay, tried that, did that, debunking, 2 opposing points of view. I'm going to line up with one. I'm going to put everything I have into it. And then I thought, this isn't really going. So what I did, I didn't do it today, I'm sorry. I bought Western wear. I didn't buy it, but I didn't wear it today either. So I started wearing cowboy boots. I have 2 Stetsons. I started just thinking, it's not if you can't beat them, join them. It wasn't that. If you can't beat them, co-opt and confuse them. So I think that's the first time I've used that particular slogan, but I could use it on a t-shirt, or maybe you could use it on a t-shirt, because I think everybody has said some version of stark choices might work in some zones, and certainly compulsive, mandatory, we're going to pin you and you're going to be nervous and shut up because you've been pinned. That's very persuasive. But mostly I think people were saying some version of this is different in different situations, and either or constructions. I mean, you did use the word binary. That's not really working. And it's just much more stimulating and fun to be inside what you once saw as a very divided battleground. It was just more fun to stand in the middle and say, well, if you were planning to have someone in the middle to scorn, well, here I am. But maybe we could have a discussion. Maybe I could be the moderator or something. So that's what I think was the dream here, is that I might be able to say something that would be like, well, there's other ways to do it, to say trade-offs still suggest that there's something, or I shall trade you this for that. And I'm getting the sense that maybe it's not that clear here. So what I would like to tell you about is a wonderful project at the Southern American West, the now decentered Southern American West. So it's not the Southern American West, starting again. So what used to be the Southern American West now still has launched a project on interpreters and translators in Western American history. At any treaty negotiation between Indians and whites, the most important person there is the interpreter. Nobody writes. We write about the generals, we write about the chiefs, what people labeled chiefs, and the interpreter is in the middle and carrying the weight of the whole event. And if that interpreter performs well, fewer people will get killed. If the interpreter screws it up, then expect mortality to go on that. So I didn't have that in my initial notes here, but I just thought maybe that's what would be helpful from the Western American history scene here, is the empowering in the 21st century of the example of these poor souls, most of them not prospering leading citizens, who stood in the middle and said, I think what they're saying over here is this, and I think what you're saying, because it's possible to do full disclosure and still leave everyone deeply confused. And depending on what form of data collection and transmission you have, the more complicated the calculations, the more likely you can disclose and no one will know that you did. So that can't be what transparency means. I want to just quickly say that I think paradox is the magic word. I spent too much time thinking of contradiction, thinking of even hypocrisy or inconsistency. And then it just seemed like paradox, by which two things seem unrelated, but actually are very related, that is true not only for the process of deciding transparency and disclosure, but also for what you do when something gets transparently disclosed. So that would be, and then I would just say that one of the great things that's going on in the field of Western American history could have been disclosed anytime over the last 150 years, but no one did that because only one historian and his proteges asked the question. So I want to conclude with that every teacher in every high school American history class has a unit on manifest destiny. Anybody here take that? Yeah. So Drew Eisenberg, University of Kansas, is writing a book, and it should be out soon. He has a couple of proteges, and it turns out that term was hardly used in the last half of the 19th century. John O'Sullivan, a hack journalist, coined it. He was proud. Nothing much happened. Then historians in the early 20th century, trying to write a history of the United States that would be unified and wouldn't just collapse under the weight of the Civil War, they went back and dug up that term, manifest destiny, and started using it all the time. So no, most westward settlers did not think of themselves. There's no evidence, how can we prove or disprove? No evidence that they thought that they were creatures of a divine mission occupying the West on this mission. They wanted land, and if it turned out that the Pacific Coast became the Pacific Coast Republic and they got the land they wanted, and it wasn't kind of modeled on the United States, but they were okay with that. So when you think of all of the nonsense given in high school history classes by well-intentioned people, the American people believed in manifest destiny. No, a hack journalist coined a phrase and then it got revived and revitalized. So I'm ending with that because it probably seems to have nothing to do with anything, but also because I think it's key to what is it that human beings are saying to each other, and when do they accurately assess what they're saying to each other, and when do they just go down a path that's entirely different? And so I'm thinking that is at the core of the question of what is functioning as transparency and what is a failure of that and what is a irritation and imposition with that. I hope that made some unit of sense, and I can talk to people privately afterwards if you were saying what that have to do with anything. But keep an eye out for that book, Andrew Eisenberg, on a reconsideration of manifest destiny. So
I will keep an eye out for that. I am intrigued by this middle position that I think both Chris and Hannah, and actually Emily too, sort of positioned this, which is like, we're not into these binaries, we're not into this trade-off language. We've got these other tools that will help position us more strategically, to use Patty's words, in the middle. And I'm going to pose this question to Eric while hopefully you all are readying your questions, because I'd like to just hash out as many questions here at the end as we possibly can. But Eric, does the middle have firmer constitutional grounding than other forms of transparency? So these impact assessments, audits, research access, all different angles into mandatory disclosures, or maybe they're not. Should we think of those as mandatory disclosures? How should we think about them in the constitutional moment that you set up for us at the beginning?
So there are a lot of things that could be in that middle ground, and
Okay.
I'll talk about the three you mentioned, but just to be clear, if we're talking about trying to understand editorial processes, I reject the premise of that question at its core. So, it's like, well, what if we do it less sensorially? I'm like, you lost me there. You know what I'm saying? If the goal is to control how content publication decisions are made, then I think we have the wrong goal and we need to reject the goal on its premise. So you say something like impact assessments, and I don't really see the role of that when it comes to something like content moderation, at least from a transparency angle. That's really the whole point of doing impact assessments when you think about it from an editorial standpoint is to say, think before you publish, which sounds pretty bad, actually, the kind of thing that we probably would not support. The audits, I do talk about audits in my paper. Audits basically just deputize a proxy for the government to come in and ask the questions that the government isn't asking directly. And the problem with audits, at least for my purposes of the taxonomy that I laid out for you, is that if we question the auditor's integrity, you're going to have to get all the data that was supposed to be not available to the government anyway. It just becomes a proxy for they gather the data, they review it, and then if we question what they're doing, we've got to look at it again all together. So if you trust the auditors and you're willing not to second guess them, perhaps that's fine. But I don't think anyone does that. See, maybe Arthur Anderson. And then researcher access, and I talk about this in my paper about scraping as one example. Scraping, I think, does solve some problems. It raises a bunch of other problems. And so I think that's a great example of a true trade-off, right? What do we get from scraping and what are we going to give up? And the thing that we didn't talk about, there's, some competitive gaming from scraping that I think needs to be considered. But it's like, there's simply like a volume issue. How many different researchers are all sending their scrapers out and how much does that impact the functioning of a website? They're not there to be scraped, they're there to actually serve their clients. And so the scraping becomes like a tax or a burden on top of the actual functioning of the operations. The other form, and we talked about this, I believe, in the first panel, was that companies can provide data sets, but if they're pre-digesting the data sets, then that doesn't solve the problem because they're laying the foundation for the researchers to find only what they want to find. And if we don't believe that they're if we want to question whether they're pre-digesting the data sets, well, then we're right back to the same problem, which is the government has to come in and say, we don't think you disclosed everything. And now we haven't really solved the problem anyway. So I think that, really, I think the transparency itself is supposed to be the middle ground between outright censorship and between market forces laissez-faire. And so transparency is like, disclose, we can watch, and if we don't like what we're doing, then we can let the market decide, or we can come in and intervene based on that disclosure. I think the middle ground of transparency actually kind of starts to get that muddled. So I actually prefer looking for alternatives to binaries as well, but here I actually think that anything that we're going to do that's an alternative to yes, the government can mandate it, or no, the government can't. I think we're going to find is probably actually either not solving the problem or it's actually just as bad.
Chris, Hannah, would either of you like to respond to that while I drum up a student question? I can't quite tell who's student, so I might need Margot's help.
Hannah, do you want to jump in? I can venture something.
Do you want to go first, Chris, while I formulate my thoughts?
So I will just say, not only am I not a data privacy lawyer, I'm also not a constitutional lawyer, and definitely not a First Amendment lawyer. And so know a little bit about Eric's work, but cannot speak kind of convincingly on the potential susceptibility of I guess like a wider ranging transparency mandate to a First Amendment challenge. I will say, what can I say? I feel I know just enough to be dangerous about the intersection of First Amendment law with, again, the space that I'm most comfortable with, which is pharma and biotech. And there too, I cannot name the case, but I know that there are cases where drug companies or pharmacies or other holders of valuable data have been obliged to share with regulators certain information in their possession. And I think those were subject to compelled speech challenges. And I think that those survived to some extent, which is to say, some kinds of transparency forcing regulations, I think, have endured in that space. I think they've been cut back, but, and Eric, please.
Just want to make sure everyone understands. I mean, this is a very common conversation that we have when we talk about compelled speech. Let's look at all the places where it is permissible. Now, why, by analogy, would this be different when it comes to the publishers being forced to disclose? And I just want to be clear, like the threat models, when it comes to publisher control, transparency, are very different than drug transparency. Things like in drug transparency, you're worried about things like competitor gaming. Well, that's actually not an issue with publisher transparency. Usually the publishers aren't the ones trying to game each other. Instead, we're worried about things like government state actors who are looking for ways to game the system, or we're looking at things like the trolls or the spammers who are looking to game system, or we're looking at just the flat out censorship. How can a government actor shut down a line of conversation they don't want? And you just don't have that with the drug issues. It's just qualitatively different. That's not to say we can't learn something. I gotta say, I already learned some stuff from your talk. It was really great. But I think it's qualitatively different than the concern I have.
Appreciate that. Oh,
Can I
Hannah,
just,
I think
Yeah,
also
Hannah wanted
Hannah
to
looks
say
like she
something.
wants to say
Sorry,
something.
Yes, go ahead, Hannah, and somebody give that student a mic.
So I think the hard question that is raised by this distinction, right? Like maybe it's easy to say that certain kinds of regulation are unconstitutional with respect to publishers, but potentially constitutional with respect to the pharma industry. Doesn't mean that the pharma industry isn't going to use the First Amendment to try to align itself, like position itself to be more like the publisher than, right, a producer of widgets, right? So the first, I think, hard question is, to what extent are the First Amendment arguments going to be categorically limited to a certain kind of industry or business model? And I think that it's really hard to anticipate how they might be leveraged in other contexts. With respect to the question of, right, impact assessments or audits, I think that the arguments, the First Amendment is probably going to be sort of bandied about as an argument against these kinds of interventions, both for social media companies, but also outside of that context, right? So when I think about regulating automated decision-making in, for example, the employment space. So New York just enacted a new law that prohibits employers from using certain kinds of automated mechanisms to screen employees unless they adopt certain safeguards, including audits, right? Could we foresee a potential First Amendment challenge to that kind of law? Could an employer or the maker of an employment algorithm make the argument that forcing us to open this code to scrutiny is itself a form of compelled speech? Of course they could, and they probably will, right? Because we've seen this argument in many, many contexts, because it builds in part on the notion that informational exchange is of necessity always speech. And to the extent that courts accept that baseline, then like many different kinds of commercial conduct that rely on data are going to be speechified, and thus regulation of those kinds of conduct are going to become vulnerable to First Amendment challenge, right? So that's not a comment on like, are the First Amendment challenges meritorious or not, but rather, like, I think we need to think about these kinds of interventions through a First Amendment lens, because inevitably this does appear to be the direction that courts are taking. And so I think that speech-like challenges to what we might have previously thought of as like ordinary regulations of conduct are becoming more and more frequent.
Just to say that I think historians are so chronically driven mad with frustration because the people of the past, a good share of them, are dead, and they just won't disclose. And it's very irritating. And they're just an annoying group of people, really. And so I think like James K. Polk declaring war in the Mexican-American War and saying that American blood had been shed in a Mexican cornfield. No, not exactly. And so all the time we have spent trying to think what we know Polk was squirrely in declaring that war. We know that, but we can't get inside his, I'm not sure we want to get inside his mind for heaven's sake, but it just seems like we are forever vexed and frustrated. And so our expectations are really modest for disclosure. And maybe that makes us a happier people because we have nothing that approaches, that goes anywhere near high expectations for what we will get from information about our fellow human beings. We're just always in a state of dismay over the fact that they're hiding from us because they died, which is very frustrating to have them just shut up from that. So I just think that we might be some kind of useful model that we have had. You may not think this, but we actually have made our peace with the fact that disclosure is always partial and now senses of that. And our expectations are very modest because they've had to be, and maybe that makes us happier people. I don't know, but I think the word, Eric, you were using the word accountability as something that could figure, or was it, oh, okay, so the word accountability, we would like to do that. We would like to say James K. Polk was entirely responsible for the invasion of Mexico, and we'd like to hold him accountable. We'd especially like to hold Richard Nixon accountable. That would be a great joy, but he's squirrely too. And so we get more squirrely than we get full disclosure. And maybe you want to join us in having more modest hopes.
Yeah, I mean, this question of whether transparency makes anybody happy, I think is a good question. And whether more information makes people happy. And you're absolutely right. Historians have a relationship, a methodological relationship with the records that they have available. And I think whatever new regime, hopefully a new regime comes in this space, we will have to come to terms with those limitations. Let me turn to our student question, please.
Hi, my name is Jacob. First, thank you all for speaking. I find it very interesting. Just hearing from all of you who have, it seems very different backgrounds and interests and perspectives. But I just want to ask you, Patty, if you could talk a little bit more about that time where you were sort of navigating in the middle. I guess what I'm curious about is, even though you were positioning yourself in the middle, weren't the people around you still kind of aware that you were still on the side of, revealing the truth and talking about what happened?
Thank you. That's a great question. Okay, so did I really ever did I convince anybody that I had repositioned myself? That's part one of the question. And I think that by repositioning myself, that was an external performance, and then it became an internal performance because then I was listening more to the diverse sides. And so then I was never as clear about thinking this is my ringing conviction. So I ended up getting as confused internally as I was externally. I also got many better stories to tell because I was hanging out with people and learning things, and I'd do anything for a story. So that was true. But I think you can still watch me in public struggle. And that probably is the basis of my credibility. So in Western American history now, many historians use the term settler colonialism to describe what we used to call westward expansion. And I don't go there because, in my opinion, that framework is supposed to give more recognition to the dispossessed Aboriginal people. In fact, it kind of squishes them into victims, passive victims. So I don't really care to be part of that. But it also homogenizes the settlers. And I'm not interested in that either. So settler colonialism now is in some ways, maybe it was what came after my book, Legacy of Conquest, that we will condemn the settlers and see them as, well, for heaven's sake, they are responsible for the displacement of Native people and for ongoing inequity. And that's all there. That has to be, but they're very diverse people. And so you can watch me in discomfort and struggling to get my footing when I take on that term settler colonialism and say, I can't join you in that. And it's not because I am now wearing Western wear. It's not because of that. It's that I really don't see a pendulum swing as a satisfactory, a pendulum passes through the middle and then it's off again. to an edge. So I just feel that when I am able, this is a, boy, what a night, I'm going to just say this, it's kind of preposterous, but when I am able to monitor myself and speak honestly about what seems flawed in the various sounds coming at me from different sides and still trying to reconcile and still trying to listen, I think in some way I'm serving my troubled nation, which is a ridiculous thing to say because you can see what an impact I've had. Whatever, you can just imagine how bad the nation would be without me doing this. So that was a really silly statement, and I'll deny it if you ever quote it to me. But okay,
It's fine. Great, thank you. Can
yeah,
we,
let's tuck it in.
yeah, lovely question. This one in the middle of the room.
Hi. It seems like a lot of discussion both this morning and this afternoon about disclosure and accounting it's a larger problem of discovery and litigation as it is. In this case, government, the public is trying to find out what personal data you have. And now the EU under the GDPR is requiring mandatory disclosure. Everybody's gearing up in this country for expected more regulation and mandated disclosure of personal data and the data behind algorithm intelligence-driven machine making. But like in discovery litigation, and like I think Andrea, who represents companies, is that everyone kind of realizes they have valuable data. They're being required to disclose it. Almost universally, they never want to disclose it. And this debate now seems to be identifying why it's impossible, why it's very expensive to do, why the data is all disaggregated in different databases and in filing cabinets, and they're afraid that they're going to disclose proprietary information, trade secret information, information they don't want their adversaries or competitors to have, or to disclose HR problems in the past and open up the door to more liability. So it seems like we're going to go through a long phase here of data companies and platforms fighting any sort of mandated disclosure because they have a whole host of reasons why they don't want to do it. The EU has bitten the bullet, and they're requiring it. Although we do hear that there's a lack of budget or data attorneys to force disclosure, so they're going to go through that phase. But I would just hope that all of the players get on board that they're going to have to do it, and rather than drag this out for 20, 30 years or whatever, and do it in dribs and drabs, because I think that they're sitting on a mountain of data, and their business model is predicated on making billions of dollars on this valuable data that is personal data. They're using it to market and sell advertising, and how can they avoid admitting that this is valuable personal information that's driving marketing, decision-making, personal lifestyles, and that I think the U.S. should finally come to grips and force this, and it's being misused for proving insurance, mortgages, loan and credit ratings, and that people have a right to find out what they have on file, in what form, in what detail, so they can start to control it, and that their lives aren't being driven by a mountain of data they can't get access to.
I'm going to suggest that is a question of sorts for Emily. Emily, does that sentiment, does that sentiment, does that sentiment land at Meta? Does that sound like how you guys are coming to terms with this, or are there parts of that you would take issue with and say, look, that's not really how we're seeing the regulatory landscape?
So I think there's a lot to what you just said in terms of the variety of legislation, regulation that is happening and the implications for personal data and how it's being dealt with. From where I sit as more of a research expert, I think we're here because I'm here because I think transparency is important and I think it can be impactful. I don't think it is the end all and be all that it's the perfect solution. We've heard that all day. But it's one of the tools that we have right now to address some of your concerns.
I mean, just a
Oh, of
couple of
course.
things. I think that your remarks really highlight for the audience the spectrum between privacy laws as a protection for individual data and what I've been focusing on, the transparency to the editorial operations of the services, which I think is a different qualitative issue than the one that you were actually focusing on, and one that I would encourage you to potentially distinguish and say, I understand that I should have the right to know what is going on with respect to my data, but I don't have the right to know what's going on in the head of an editor when they're making an editorial decision. That's something that's just not my purview. The other thing I just want to mention is that the movement today is towards forcing companies to make these disclosures before there's any litigation at all. And so you were talking at the beginning of your remarks about discovery. And I just want to point out the differences with discovery. Discovery only occurs here in the United States after there's been a complaint that's been filed that's subject to things like Rule 11, and that the judge has not granted a motion to dismiss, saying, I think there's enough merit to let this case get to discovery. And then within discovery, there's rules of engagement, like there has to be relevance. You don't get all information. You actually have to get the information that's relevant to the legal violation that's in the complaint. What we're seeing with the movements towards mandatory transparency inverts all that and says, we don't need to get to discovery to find out. We don't need to show that there's a legal violation. We get to see everything, even if there's no legal violation whatsoever. And so it's a qualitatively different thing than discovery. And it actually helped remind just how broad an ask it is. That doesn't mean it's a bad ask, but it definitely is a broad ask. And that raises a lot more concerns about why are we requiring this data? What is the cost of this? What are the risks to disclosure when there's no judge supervising this battle between the parties? Last thing I'll say, you did say you're going to have to do it. You're sitting on billions of dollars of revenue. I think you may have had one company in mind, but I will point out that the ecosystem is really quite broad, and there are many services that are not sitting on billions of dollars, are not sitting on billions of pieces of people's data, and we should not ignore that they are going to have a qualitatively different decision than the giants.
Thank you. Can we get Jeff a mic? Jeff, can you raise your hand?
Yeah, I just quickly wanted to react also to the previous question and give the European perspective, if you will, in the whole range of laws and proposals that we've seen suggest in the last couple of years in Europe. As I said before, there's this common denominator of transparency and compelling data access. I think how I read it in across these different frameworks, there's to me a clear intention to break up to not have businesses build an entire business model on data in itself, and to force companies to not silo off their data, and basically to have business models form around what you do with the data rather than hoarding data, if that makes sense. And I think that's an interesting thought experiment. I'm not sure where I'm standing on the European Commission's perspective here, but these business models that we've seen emerge in the last 10, 20 years, we've sort of come to accept it seems, and as a natural law or something, that these companies should have a right to shape their business model around this. But I think it's an interesting thought experiment to see, maybe that's not okay, and maybe data should run freely, and it's more like what you do with the data.
Who else has a question? I think we have time for at least one more, right? Oh, think you're a long way from a mic. Here we go.
Yeah, so this is to Eric, but also to the other panelists. First of all, I think I mentioned this in a one-on-one conversation. It's fascinating to me that the sort of chilling effects arguments that you're making around disclosure and editorial policies are like the same foundational arguments that have been in place in both Supreme Court cases and in private litigation around the anonymity of speakers. And so it's just fascinating to see these arguments. You want to talk about narratives, these arguments about chilling effects and the benefits of privacy for communication now being, they get applied selectively, right? Like they get applied to, we see this in FOIA too, right? Like in open records laws, where you have an open records law that will say, we need a disclosure in the name of government accountability, and the exception there is going to be for deliberative conversations, right? Before you get to the final policy, we don't want to chill the making of policy, and so we don't allow for disclosure there. Yet when the same argument is being used about personal privacy, it dissipates. So that's more of an observation than a question. The question I had was, if there's this poll of editorial decisions, clearly speech, transparency becomes a chilling effect in a way that's so tightly intertwined with actual traditional historic speech that it's problematic. And then on the other side, there's something, once we get into privacy or other places where information is being exchanged, as opposed to there's this traditional historic editorial context, there's room there for transparency and for disclosures. Where's the boundary drawing, right? Where do you decide, and I guess this is back to Amanda's work too, where do you decide this is unacceptably close to core First Amendment values and interests versus actually the transparency is serving core First Amendment values, even if it's not something that's required under actual First Amendment law?
Yeah, I think it's actually helpful to analogize to traditional publishers for a moment, which is always a little bit dicey, but work with me for a moment, then we'll see if it blows up. Think about the integrity of a traditional publisher's newsroom, that we put severe limits on the government's ability to come into that newsroom, to grab information from that newsroom, because the simple presence of them there, it put at risk a journalistic function. It put the risk that the journalists couldn't go out and gather information that might be sensitive, that might be under a shield expectation if the government can just come and grab stuff. And because of that, we generally haven't seen the kinds of demands for exposure of editorial decision-making in the traditional world. We're now only seeing it today in the internet world. And what I find so fascinating about that is that traditional publishers almost always become concentrated markets. That's the feature of all media niches, is that they become concentrated. So there's always people with market power in those niches who have had huge impacts on the conversations that fuel our democracy. If you think about the local newspaper circa mid-1970s, if they ran an editorial against a politician, there was very little that the politician could do in response to that. They had to scramble to find alternatives. And yet we accepted, I think, tacitly perhaps, silently, that we couldn't require the newspaper to disclose how it decided who to endorse, and why they decided to endorse, and where they decided to put that story, the front page, editorial page, or somewhere else. We just accepted that those decisions were not in our purview to be compelled. If we didn't trust them, we could ask questions. If we could drop our subscriptions, we could protest. But we accepted tacitly that those were just off limits. And to me, I feel like we're doing a redux of all that except we're bending all the rules. It's like, okay, there's this thing called an editorial function. These are the content reviewers and the public policy and the product policy and the trust and safety teams. They're all working together to decide, what do we want to publish our audience? I'm like, tell us everything. This is all fair game to the public. And without it, democracy will fail. And to me, I can't wrap my head around that dichotomy. That doesn't mean that there aren't differences between the two, but I don't find any of them persuasive enough to say that we would choose to allow the government to intrude into the functions of these publishers where we would have never accepted, I think, in the other types of publishers.
Hannah, do you have I can see you thinking on your little box up there, and I can't tell if you'd like to hop in, but I'd love you to, if you do have a response to Margot's question or Eric's response to it.
I guess I have a small footnote to Eric's response, which is to say, it's hard. I mean, this is not fully thought through. A bad thing about my face is that my thinking is visible. So my thinking is not complete on this. However, I will say, I think that we, over the last century, have seen the traditional news media make a series of editorial discretion arguments about different forms of regulation that have not always been successful. Right? So we've seen this argument about editorial discretion be made, for example, in opposition to antitrust law or to labor law, and courts have rejected it. And so there are limits to the notion that editorial character creates legal immunity. And the question is going to be where those limits lie. And it's not a settled question with respect to either the traditional media or with respect to social media companies or platforms or any of the sort of data-driven business models that we see emerging today that also are sort of donning the mantle of editorial discretion. So two that I'm thinking about here are Clearview AI, which exists to be a to be a search engine, but only for government customers, and says it has a First Amendment right to do all sorts of privacy invasive things, even though it's essentially only a government contractor. And the other one I'm thinking about here is just slipped my mind because my thinking was totally incomplete on this. So I think that there are potentially areas where the law is not yet settled on these questions. And so thinking about where it should take shape is an important sort of exercise as we enter this next stage of policy making. And the answers are not obvious to me.
It's a perfect way, I think, to end the panel. Thank you, Hannah, and thank you all of our panelists. Please help me in thanking them.